Being recorded.
Oh, okay. Sorry, we forgot to start the recording. After introducing briefly the kind speakers, Dr. Stauch, Dr. Snyder, and myself, Giovanni Comandè, we moved to my own introduction and my first intervention as a speaker. As usual, the organization is we will have short speeches, roughly 10 to 15 minutes. Colleagues can take longer if they think, but enough to leave room for discussion, because as said, while not recording yet, we aim to have discussion, raise awareness with our series of awareness panels. So I am at the Scuola Superiore Sant'Anna. I chair the Leader Lab, as I mentioned, the Laboratorio Interdisciplinare Diritti e Regole, where we cover several areas which are, I would say, highly related from many angles to the entire SoBigData++ project. You see our areas of interest. And we have quite a number of competitive projects. And as I was anticipating, there is a SoBigData family to which SoBigData++ belong, which is a key point in our areas of research in data governance, data protection, intellectual property, and so on and so forth. But let me not steal too much of your time, and let's jump on medias res directly. Okay. So our topic today is basically secondary use, further processing of health data for research purposes. Now, before we move in that direction, it might be useful, being the first speaker, to very, very quickly give a brief overview of what are the challenges and the importance of trying to harness further data for further processing data in general, and especially in health data. The awareness panels clearly inserts itself in the moment in which there is a boiling activities also at normative level, the proposed regulation for the European health data space, the projects sustaining the development of other infrastructure, even beyond SoBigData, for instance, for genomic data, the GDI proposal, which is building infrastructure, aims all at further sharing of data. That, as you can see from this slide, highlighting the hurdles, the roadblocks, there is a clear need from many stakeholders to enhance, to enable more sharing of data. Indeed, the more sharing of data would be fully in line what is basically the EU data strategy, always with the same framework in mind, which is, if you want, the philosophy of SoBigData++, we embrace very fully the mantra, if you want, of the European Commission. We want to foster reuse of data, of course, according to this, what I call banded openness. So we want to open as much as possible data, but keep them as close as necessary to protect fundamental rights. That's basically the logic for the data agile economy of the European Union. Now, what is putting at the center of the stage the secondary use of personal health data are a number of convergences that move from technological to institutional, organizational, legal ones. So we realize there is a convergence of rapid progress in medical research, and a buzzword is personalized medicine, which is completely disrupting the traditional ways in which we aim to share health data. So it's not anymore the usual loop from research to medical products, medicinal products, eventually to the bed of the patient. But there is a direct need to access health data from other patients, for instance, in specific and large domains, moving beyond some domains which were traditionally the ones interested by this process, like rare diseases. Okay. So this is completely changing and envisages deep changes in not only in the need for data, but in the ways technically in which data are to be shared. So health management data are becoming key of health data for delivery of healthcare services, for research and for other purposes, and research data are aiding the other ones. So there is a need to move beyond traditional boundaries, which, by the way, it's also meaning beyond purposes. And that brings us to what is our first main regulatory framework that in our understanding has to be an enabler, not a roadblocker. Although, as we shall see in the proceeding of this brief discussion, the GDPR, while it wants to open data, to contribute to an increasingly opening of data, still presents some hurdles that we need to overcome, at least at the level of interpretation. Now, let me stress that very often we talk in terms of ethical needs to share the data. There are constraints, and data protection is seen as also as an ethics needed constraint. But I will stress here that is, to me at least, it's an ethical issue, not leveraging enough the data, because not removing roadblockers to sharing health data according to the mantra as close as necessary, as open as possible, literally means that people don't get access to proper treatment. Literally means that some researchers that can save lives are delayed. So there is, to me, it's an ethical imperative that we have to do all we can, and that's what we are doing with this, to overcome hurdles, roadblocks. Also because there are a number of other risks that are in front of us, including disparity across regions, where regions can be European regions, but also within each member state healthcare systems, the sharing of data may be really fragmented, also from a regulatory point of view. Now, I already anticipated that to me there is a legal and ethical need to bridge the words that basically is normally related to the patient, so the clinical arena, with the research one. Those boundaries are collapsing for good, I would say, and we need to govern that process, avoiding the risk. But let me go very quick on these risks. The slides will be shared later on. There is a clear risk in creating parallel worlds. For instance, if we don't bring together different initiatives like the GDI and the European health data space. But let me really jump and really skip part of my presentation. I assume that all of us are pretty much aware of what are the scope of the tools proposed in the European health data space, what kind of connections it will foster. And for sure, we should take into account that the European health data space as an ability that it's going beyond all the other proposal legislations in the framework of the data-driven economy by the European Commission. It expressly envisages as a new legal basis the sharing of health data, something which is not provided in any other tool or means. So really it's a bold move that has been done, probably a needed one, because by definition, it is trying to strengthen already existing and developing and expanding tools at European Union level. But let me turn, after just stressing how interconnected the various proposed legislations are, especially in the domain of health data, let me immediately jump to the further processing, because that's where I would like to challenge the discussion more. Now, it's clear that the European health data space is aiming at secondary use of data, but as I anticipated, all the aims like interoperability are built on the possibility to expand the legal basis for further use of personal data. If we take out, okay, this option, which is clearly offered by the proposed European health data space regulation. So basically, once data are in the European health data space and are shared under those safeguards, they can definitely be more easily shared, and they can more easily share it not only for research purposes, but those existing borderlines between clinical, managerial, and research use of data is increasingly interconnected, and to a large extent, the boundaries are in the pipeline to be overcome. But that applies only if the data are actually in the European health data space. Being in the European health data space doesn't mean they go necessarily in one repository. Okay, let's leave alone the technical part, how they will be shared, accessible in a federated way or other ways. Okay, that's not relevant for this discussion. What is relevant for this discussion is that if we set aside the European health data space, we start to have serious problems in dealing with the legal framework. First of all, as we have stressed in a joint article published with other colleagues, and also in some articles actually shared and published and written with Dr. Schneider, for instance, there is no broad consensus at all on a clear definition of what is secondary use of data. So what is further processing as secondary use? Very often, even the terms are used in an interchangeable way, along with other expressions like data reuse. So secondary use is it further use, is it data reuse, or repurposing? Okay. There are many ways, and the conclusions we reached in a published article is that basically these terms should be maybe differentiated according to their context of use. So, for instance, in the compatibility test, by the way, of Article 6, paragraph 4 of the GDPR, it's requesting to somehow check the similarity of the context of the purpose, so clinical aims, research question, across the different uses, so the original purpose and the new one. But there are some more clear definitions that emerge. For instance, the idea to use further use as the use done by the party that originally collect for its own primary use the data, distinguishing that they use as a secondary one if data are basically used by a different data controller. So there are some advantages, as we shall see in a moment, in separating the initial data generation of data. So I am collecting the data for a specific research purpose, for instance, or I am a research hospital that has gathered clinical data, is enabled to use them for their own research, and then, for instance, sharing for a third-party project or a research project which is not only my hospital one, or even sharing in the European health data space or in the GDI or in another instance. So when do we have, what's the legal framework? You are all well aware and skilled in secondary use rules. So in principle, the recital 50 is suggesting that we should be able to process data for purposes other than those for which the personal data were initially collected. And actually, when we deal with the consent, another recital is also suggesting that data subjects should be allowed to give broader consent. Still, okay? Article 5 of the GDPR states that that data should be collected for a specific, explicit, and legitimate purpose, and no further process in a manner that is compatible with those purposes. There are a number of exceptions, we do know it, but basically are legislation, member state and state ones. We do know there is the so-called research exception. So for archival purposes and the public interest, scientific or historical research purposes, if we abide to Article 89, paragraph 1, there is a presumption of compatibility in the secondary use or further use for the time being. But that's only a presumption that doesn't cover the legal basis, for instance. So if we look at the compatibility test in all its entirety, the compatibility test can be postponed if you want, in case of there is someone contesting the presumption of compatibility for research purposes. But if there is someone contesting that there is a compatibility for the new research, and think about the Tiziana cases in which the same kind of research originally consented for public interest for a public non-profit institution was then repurposed, or better way, the whole project and data were acquired by a private entity abroad in UK, changing completely the scenario. So still, the compatibility test doesn't carve out, for instance, the need to have a legal basis, okay? Nor it carves out the information duty under Article 13 or 14. Now, broadly speaking, there can be two general approaches to secondary use to understand what constitutes a further processing which is not a secondary use. What we call a data-focused approach and a controller-focused approach. In the first one, basically, processing for an additional purpose concern the entire life cycle of the data, from data generation to deletion. In a so-called control-focused view, a distinct phase within the data lifecycle is defined by who is processing the data and for what purpose. So in the second one, it's who is the data controller that somehow define the nature, whether we are doing secondary use, okay? Now, in the control focus view, each phase in the data cycle governs, okay? Further processing under the GDPR is understood in relation to the purpose of which a particular controller originally collected the data. So I collect the data for purpose X, and Dr. Snyder gets the data from me. Or in the controller focused view, she's starting for her own primary purpose by doing secondary uses of the data I have collected, okay? She is connected from a different source. In this case, it's me, not directly the data subject. Now, this is creating problems, and there are some problematic cases in which, as I anticipated in the introduction, the convergence between research and clinical diagnosis is collapsing, creating problems with the approaches. So, for instance, for rare disease patients, and if we stick to the example of genomic data, rare disease patients and their family members are commonly subjected to extensive molecular evaluation, even at clinical level, in order to try a cure, to define what would be the best path for diagnosis and treatment. And the evaluations might have a clear immediate impact on the patient treatment. On the other hand, the very same data processing can have a very clear value for research activities, for statistical analysis, or for finding evidence from similarly situated patients. So still a clinical trial to say, okay, look, in that rare patient, that treatment with this dosage had a similar effect, and this is related to such and such genomic variation. Okay. So again, this is showing how the borderlines are collapsing between the clinical, the managerial, and the clear research. And it remains unclear whether the use of the patient data for research purpose would just constitute secondary use at all. So this opened to another issue. I'm just throwing at you problems, not solution. I'm aware, but that's done on purpose. Not all intended purposes are primary one. So again, it goes to the general requirements of the GDPR. Consent eventually needs to be specific. And the level of specificity that emerged from the DPP guidelines from case law seems to go toward the direction in which it should be, first of all, specific enough for research, for instance, to define the research protocol, and should be specific enough in the purposes definition to carve out all opportunistic processing purposes. So highly specific. Now, if you start thinking for further processing, for data sharing, this is creating a number of hurdles in many ways, organizational, technological, and of course, in terms of legal factor and the legal framework. Now, in the article I was advocating, we have come up with some tests to understand where the purpose is a primary one or an opportunistic one, because they have different ways. So, for instance, if the starting processing activity is medical hospital A, sharing records collected from the patient with hospital B, and hospital B, that's the scenario, intends to use the data for a diagnosis of patients. Okay. Now, what is secondary use? What is further processing? If this controller dependent, hospital A discloses data to hospital B, it's further processing. So the legitimate compatibility tests, it's on the basis of the original purposes. Okay. But it's supporting diagnosis. So there is no research, there is no presumption of compatibility. Okay. Hospital B obtaining the data and is just running a new primary processing. Is it secondary use? Yes, it's a secondary use because it's done by a different data controller. Okay. And of course, while hospital A must have a legal basis for sharing, hospital B must have a legal basis for actually processing for its own primary purposes. And there are different duties. So the compatibility and the duties on hospital A is to check whether it is allowed to share for the other purposes and the compatibility. So different constraints, different burdens. There are some consequences. I'm quickly going to the conclusion. I've talked too much. Apologies. So who is going to have the duty to carry out the compatibility assessment is the data transferring controller. It's hospital A. Okay. So this basically enables the fact that it is possible to share data with multiple independent control without any further processing taking place. It's the approach for the population biobanks, for instance. Okay. So in this scenario, access is not a further processing, it's a primary one of the second, of this, our example, hospital B. Okay. Now, there are a number of other issues that I would love to raise, but I'm stealing too much of the time, so I will just stop here with a conclusion that is going to the debate, that we do need to try to bring together these different kind pieces of the puzzle from the framework, the legal framework as enabler, trying to find what are enablers and blockers, and to see whether the technical solutions can help finding a simplification both in the legal framework and in the way in which the data sharing activities are organized. But now stop here, and I immediately leave the floor to Julia Schneider. Thanks, Julia, for being with us again. I briefly introduce yourself. Let me stop my sharing so you can share your own presentation, and I leave you the floor. Thanks a lot.
Thank you, Professor Comandé. Do you see my screen?
Yes, perfectly. Thank you.
Perfect. So first of all, thank you very much for invitation. It's a true honor to speak today together with such prominent speakers, and I thank in particular Professor Comandé for having introduced the topic of secondary uses and of the uncertainties that are currently persisting at regulatory level regarding the legal basis for the processing and for the further processing of personal data. So many things that Professor Comandé anticipated, I will go back to them in order to inquire the topic that has been assigned to me today, namely the public health interest and the research exception under the GDPR. Indeed, it is, of course, has been a big question also under the pandemic of how and whether the GDPR, namely the European Data Protection Framework, how does it interact with research? Is it a research limit? Is it a research enabler? And so, of course, it is interesting to read closer along the lines and among the bars, we can say, of the very complex framework that the GDPR poses in order to inquire which are the spots that really enable the conduction of research and the data and the conduction of data sharing activities upon which, of course, research activities are based, and to which extent. So how does the GDPR intervene? And in this respect, it is particularly interesting to look at the public health interest and the research exception. And as Professor Comandé has already anticipated, we have worked on the subject in various papers, and so I will go back on some of the theses that we have advanced in these papers. But first of all, let me lay a bit the factual grounds of our research. So the question is really, which is the impact of the General Data Protection Regulation on data sharing and research? And in this respect, the exception regarding public interest and public health are of extreme importance. And in this respect, we thought that it was particularly interesting to frame this broader question within a more specific question, namely recalling the principle that already Professor Comandé has anticipated. What is the meaning of the principle of as open as possible, as closed as necessary, so within the General Data Protection Regulation, in light of the exception it poses to the processing of personal data? Now, as a factual background, we can say it has been evoked data sharing, but what is actually data sharing? Data sharing, we can say very generally, it can be considered as a form of private ordering of research and innovation in the European digital market. It enables collaboration for research and development purposes. So I think that private ordering is a particularly suitable notion in respect to data sharing, which comprises very different types of interaction, moving to closer and tighter interaction among, for example, businesses in the form of joint venture. In this respect, the joint venture, for example, that Google has, or Amazon, the big data companies are creating in the health sector, are a particular example. The European Commission has specifically addressed the Google-Sanofi joint venture. Or we can say, looser relationship in the form of contractual sharing, occasional interaction among players within the European digital market. As in the health sector, another a very famous example that has been inquired by data protection authorities, in particular the UK Data Protection Authority and the Italian Data Protection Authorities, are the cases of the contractual sharing between Google and Royal Fleury Hospital, or IBM and the Lombardia region in Italy. Now, Also, from a policy perspective, the European data strategy has tried to identify and conceptualize these different types of data sharing practices along the lines of so-called B2B, business to business, business to government, and government to business data sharing activities. Now, what all these different experiences have in common is exactly that data sharing gives rise to outright innovation networks, which are ultimately based on personal data, also in light of the very general notion of personal data that the GDPR provides. So the question arises, how does the GDPR interact? Is the GDPR applicable to these kinds of very different research inquiries? And it is particularly interesting also to outline that also the World Health Organization has outlined how the research paradigm is changing from a patent-based research paradigm to a contract-based research paradigm. Indeed, it has affirmed that it is increasingly common for traditional actors in the health research environment to engage in contractually relevant arrangements. Now, also this makes the case of the interaction between a mandatory framework as the GDPR in respect and with the private autonomies of the parties in sharing personal data. Activities that are strongly promoted at European policy and regulatory level. It has already been outlined by Professor Comandé, and it is not a case that we can maybe also already start talking about an outright European principle of free movement of data, the regulatory contours of which are still highly uncertain. It is true that the Data Governance Act defines data sharing, but the borders between different notions of data portability, data interoperability, data control are quite uncertain, are not yet strictly and certainly defined. Now, in this respect, let's move to the baseline, the regulatory baseline, which the GDPR provides in respect to our principle, as open as possible, as close as necessary. We have to take the last part of the expression, as closed as necessary. First of all, we know that the GDPR places some limits. It is indeed grounded in the primary objective of protecting users' personal data. It poses a very fundamental principle of data minimization, and it also established legal basis to which data processing activities have to be necessarily anchored. In particularly, we have to remind that in respect to sensitive data, so-called special category of data, Article 9 of the GDPR poses an outright prohibition, and only exceptions allow the processing of sensitive data. When it comes to research purposes, and we will go back to it in a moment, it places also outright safeguards. Now, first, also in this limits, in the perspective of the limits that GDPR poses, some first, we can say, windows that can be opened. Indeed, also the standard rule, the golden rule of consent, experiences is stretched when it comes to research. Indeed, Recital 33 expressly states that data subjects should be allowed to give their consent to certain areas of scientific research when in keeping with recognized ethical standard for scientific research. And so this broadening of the notion of contents when it comes to research activity has to be sort of confronted with the principle of purpose limitation, which of course creates some problem with this broad definition of category. But let's move to the part of the enabler. How open is actually the GDPR in its regulation of data sharing, of data flows, which are at the heart of the European digital project of constructing European data spaces, of which the European health data space is one of the primary examples. First of all, in the studies that we have published with Professor Comandé, we have tried to identify, as you can see in this triangle, three types of data protection regime. Now, moving up to the point, to the top of the triangle, where data subject control is mostly satisfied, is mostly enacted, we can identify sort of data subject-oriented regimes in terms of content, in terms of vital interest, in terms of an obligation to process personal data and the data that are made manifestly public by the same data subject. So we have here a presumption that the data subject itself wanted and has had the will to open up its data. But moving on to other legal bases that the same GDPR poses, we find some different data protection regime which have also a different rationale. We move away from the rationale of data subjects control, and we get closer, as you can see at the bottom of this triangle, to free flow of personal information objective, along the lines of what we have identified as public interest-oriented regime and research-based regime. Now, as we move closer to the research-based regime, of course, data subjects lose greater control of their data, and this sort of creates a shift from the regulatory barycenter, from the data subject to the data processor, the data controls, who, as we move further away from the data subject, data controllers are entrusted with greater responsibilities. Now, if we look at the public interest-oriented regime, the public interest-oriented regime and the public interest-oriented legal basis that you can see here listed under Article 9, which we have identified as a use case because special category of data, under the assumption that special categories of data are everywhere, and so actually it is Article 9 that we have to look upon. Actually, the public interest-oriented regime enables data sharing. Indeed, we have a strong derogation also that is sort of attributed to national member states. So national member states can also specify the public interest in order to enable data protection, personal data sharing flow. But what is mostly important is to remember that it is the same general data protection regulation that mentioned that when data and also special category of data are to be processed for public interest related purposes, for under public interest related legal basis, it is sufficient that a minimum data protection standard is observed, namely the essence of the right to data protection. What the legislator says to us is that on these grounds, personal data can be processed as long as and with the sole limit of the respect of the essence of the right to data protection. And this is stated in respect to the public interest and the public health legal grounds. We have not this reference, and we found it quite interesting, in respect to preventive medicine, health, or social care, to which this reference is not present, and so also data subjects' rights that Chapter 3 lists have to be and remain fully applicable. So we have also this distinction and this differentiated regime among different public interest-oriented legal regime. Now, moving on to the data subjects' rights, as I was mentioning, Article 23 enables national member states to lower and to compress the data subject rights under Chapter 3, and we see and we can observe the same differentiated regime. Indeed, Article 23 encompasses both public interest and public health legal basis, but not preventive medicine, health, or social care. So here we have a medium standard of enabling regime, since data subject rights have to be respected, have to be applied. Exception made of the provision of paragraph 3 of Article 9, which enables to a specific extent also the reuse for these purposes of special categories of data. And so we have, in case of secondary uses, data subject rights can be sort of all, can be bypassed. Now, within this framework, we have asked ourselves, and then I get to close because my time has, we have asked ourselves how the research regime, the research exception of which Professor Commandé has already talked about, interacts with this public interest related legal grounds. And actually, this question is not so easy to answer. Indeed, the European legislator in the GDPR does not provide any specific guidelines regarding the interaction of research, which encompasses, also in line of the broad definition of research provided under Recital 159, also commercial-based research and research conducted for commercial purposes, and it has been written also under this broad definition, also the research conducted by big data, by big companies, by big tech companies may also sort of be relevant. This definition also for the activities that more commercially relevant, the research relevant activities these corporations conduct. Now the question is how this broad definition of research interact with the public interest-based regime. A first standpoint is Recital 162 of the GDPR, which sets the very important principle of segregation. This means that the results of a research inquiry cannot then be further used for commercial-based processing operation. Now, but still, nonetheless, the notion of research remains quite broad, and in this breadth of the notion, we have tried to identify and to propose a distinction between public and commercial-oriented regimes along the lines of differential research-based regimes that have been sort of identified through the scaling of safeguards under Article 89. Now, we can skip this part, and the results of our research can be found in this graph. You can see that in case of research, the GDPR enables the compression of the individual rights under Chapter 3, enabling a greater flow. We think that ultimately, when it is a public interest related research purpose that grounds the research and the processing activity, the compression of these data subject rights can be sort of stretched up to the maximum, and the enactment of additional safeguards for fundamental rights and freedom can be stretched to the minimum. To the contrary, when we have for-profit research activity, individual rights should be sort of derogated as less possible, and the additional safeguards should be stretched again to the maximum. Now, this is just an interpretative reading of the GDPR, which has not found yet a direct regulatory or policy support, and this policy support we have also not found it also in the European health data space, which has taken a regulation which has taken a rather different path and has presented, as generally known, under Article 35 and 35, the lists of respectively permitted and prohibited secondary use. Now, also, in this regard, taking a broad sort of approach, and indeed also commercial application is permitted. And now I'm going to close with this question, opening to debate whether this sort of typical cases approach, whether the identification of typical cases under European health data space provides direct answer, provide more certainty, or to the contrary, under the facade of a more certain, greater certainty, actually paves the way to greater interpretative uncertainty, because it does not pose a certain general principle for operators to define what is permitted and not, which would be more suitable and more flexible, also in light of the very fast technological development which data processing operations follow. So I thank you very much, and I leave the floor to the third speaker, and I'm very looking forward to the discussion. Thank you very much.
Thank you very much, Julia. This has been very challenging. Meanwhile, Dr. Stauch eventually starts sharing the slides, because basically it goes to the actual competitiveness of the European legal framework, which is a topic of high importance, whether or not we can actually cope with the promises we are making in terms of fundamental rights protection and opening to research and commercial uses. Thanks a lot, Julia. Dr. Stauch, you have the floor. Mark.
Hello.
We don't see you. We don't see you.
I have some connection problems, so I have stopped my video. But can you see my screen?
No, you need to start sharing. You are not sharing yet.
Can you tell me how to do that?
Yeah, go on the bottom. You have the audio and video, and then you are share. There is like a button. Share should be written in Italian. It's condividi. You might be you are looking at in Italian, because so in case it's condividi, COMDIVIDI. Great.
Oh, is it working? Oh, good.
Perfect.
Fantastic. That's
if you
great.
put it in presentation mode, it will be large enough. Great. Thanks, Mark.
Let me do that. Okay, so the topic I have today. Well, first, could I also just say many thanks for inviting me to this to be part of this distinguished panel. And the topic that's been allocated to me is to talk a bit about the identification and other safeguards to promote health data sharing, and what is the regulatory, what are the regulatory constraints on this. And as both Professor Comandi and Dr. Schneider have already mentioned, we have this General Data Protection Regulation, the GDPR, which is now the flagship EU legislation which regulating data protection, and in particular personal data where it relates to a person or can be related to a person. The starting point of this regulation is that, of course, this data is valuable, it can be used, but subject to restrictions, with a strong onus on the data controller, the person wishing to, or organization wishing to use the data, to justify the use, and also to, as far as possible, safeguard the data from risks of misuse, or do things with the data that would in some way interfere with the fundamental rights of the data subject, the person to whom the data relates. So data protection is actually a fundamental right under the European Charter of Fundamental Rights and Freedoms, and really the regulation, the 2016 Data Protection Regulation, which came into effect in May 2018, so still fairly recent, that concretizes this general right to data protection. One can look at data protection as a way of supplementing traditional rules of privacy and confidentiality, updating them so that they cope with specific risks arising from digital use of data, i.e. the ease now of copying data, of analyzing it in ingenious ways, profiling the data subject, including all sorts of predictive analysis and things that could certainly interfere with the dignity and autonomy of the data subject. So that's why we have this data protection law. It's cast very widely. It should be said that the law is extremely general. It's not been drafted very much with health data specifically in mind, or indeed research uses of health data. The data protection regulation does try to direct some of its specific provisions to that sort of data processing, but it is a very general omnibus type of legal regulation where it's formulating principles to apply to all sorts of data use. And as I say, whereas it does try to cater for perhaps special cases such as health data use for research, it's done as a sort of add-on extra, and much of the constraints on data use are general, and that is part of the problem. It's a complex general provision, but it tries to allow for beneficial data use. It recognizes, as we'll see, that there is tremendous value for the public interest if data can be used in positive ways, but it also sets up certain general regulatory constraints on the data use, which, well, as Professor Commandes mentioned, and indeed Dr. Schneider, that this continues to pose problems for practical use of health data in the public interest, including for research use. But anyway, let's look in a bit more detail, albeit briefly, obviously, because of the time available. Let's look a bit more at the legislative provisions in this regulation, what they say. Well, all data processing must be lawful. That means the data controller, the person wishing to use it, has to show a legal basis, that they have a justification, a legal justification for using the data. That can either be the subject's consent or another basis laid down by law. In the case of health data, that counts as especially sensitive data, where it's felt that the rights of the individual might particularly be at risk if this data is used. Therefore, Article 9 of the regulation adds sort of extra and more restricted legal basis, which a data controller has to be able to point to in order to justify the processing of that sensitive data. Besides the need for a lawful basis, the data must in every case also be fairly processed, and that's to do with things like data minimization, having a legitimate purpose. Those extra conditions, all set out in Article 5 of the regulation, are on top of the need for a legal basis. It is in effect an independent necessary condition for data to be used. The data controller has to show that they are both lawfully processing the data, i.e. they have a legal basis, but on top of that they also have to comply with these principles of fair data processing set out in Article 5. Well, my specific remit was to talk a bit about de-identification and how far that helps. After all, research data is often used in a de-identified state. It is often not necessary to know the name of, say, a particular patient, where the data came from. One can use it for good purposes without needing to know who the patient is. So one might think if one can just de-identify it, it will no longer be personal data, and if so, maybe it doesn't even fall within the General Data Protection Regulation. That regulation is, after all, directed to use of personal data, so could simply de-identifying data help? Just take it out of the capture of this legislation? Well, unfortunately, it's not so simple, because it's true that recital 26 of the regulation does say the principles are not intended to apply to anonymous information, namely information which does not relate to an identified or identifiable natural person. It is just difficult often to be sure that one has achieved anonymity. it's a very, very contextual question whether specific data has been anonymized. Recital 26 here gives you the test. It says to determine whether a natural person is identifiable, you take account of all the means reasonably likely to be used, such as singling out either by the data controller or by a third party. You have to take account of all objective factors such as the costs of and amount of time required to do a re-identification, taking into account the available technology, etc., and also taking account of the fact that technology is constantly developing to allow perhaps data which has had the name taken off, allowing it to be matched after all to the person that it came from. So it's extremely context dependent and time dependent. Often in the research context, what is done with data is really pseudonymization rather than full-scale full-scale anonymization. And what's meant there by pseudonymization? Well, it's defined in Article 4.5 of the regulation, saying it's processing of the data done in such a manner that the personal data can no longer be attributed to a specific data subject. Well, the definition perhaps isn't as clear as it could be. What's really meant is that an official channel is retained so that you could link back to that data. Commonly it's done by kind of chopping certain bits of the data set off, such as the name of the patient, and replacing it by a key code, and somewhere else keeping that link, the name of the patient versus the against the kind of key code, but in a file which is kept somewhere separate. That's designed to protect the privacy and the possibility of, to safeguard the possibility the data could be misused if it's stolen, because the hope is whoever stole it wouldn't know who it relates to. Crucially for our purposes, the GDPR says this is a good thing to do. It sort of encourages, but it encourages pseudonymization, but it also says it stays personal data for the purposes of the regulation. In short, data following pseudonymization, it's a bit of a mouthful, that word, it is still subject to all of the data protection rules. So the GDPR is a bit in two minds about pseudonymization. It sort of says that it's a good thing to do, to de-identify data like this. It's certainly a protective measure. Recitals 28 and 29 specifically encourage and say it's a good thing to do, but it does remain personal data as far as the lawmaker is concerned, which means, as we'll see later, where data is pseudonymized, the data controller who has that data is still subject to various other regulatory constraints. So pseudonymizing data is a good thing, but it doesn't get rid of your obligations if you're a data controller to do various other rather onerous things. So health data, as already mentioned, it is a special sensitive category of data where the dangers of its disclosure or misuse are perceived as being particularly damaging for the interests of the data subject. And in that context, as has already been highlighted by the other speakers and Dr. Schneider in her presentation, there are specific permitted bases for processing it, but they are more limited than for non-sensitive data. And Article 9.2 is the critical article, as highlighted by Dr. Schneider. It says that if you're using data for research purposes, you either need the explicit consent of the subject, that's under 9.2a, or you have to show that you can satisfy 9.2j, where on the face of it consent isn't necessary, but instead you, the data controller, are able to show that the processing is necessary for scientific or historical research purposes in accordance with Article 89.1, but such processing is proportionate to the aim pursued, respects the essence of the right to data protection, and provides for suitable and specific measures to safeguard the fundamental rights and interests of the data subject. So it's possible to process data, health data for research without the explicit consent of the subject, but only subject to these special safeguards. And the reference here is to Article 89.1, so let's see what that says. Article 89.1 provides that processing for scientific or historic research purposes shall be subject to appropriate safeguards. Those shall ensure that technical and organisational measures are in place, in particular in order to ensure respect for the principle of data minimisation. So no more data than necessary is used, is the principle of data minimisation. It's one of the fair data principles set out in Article 5 of the regulation. It also, again, sort of says those measures may include pseudonymisation. So again, the regulation is encouraging pseudonymisation as a good thing to do, provided you can make valuable use of the data in that form. And indeed, it goes further. It says, if you can make valuable use of the data in fully anonymised form, you should do that. So best of all, try and use anonymous data. If that is not practical, if the, say, the research purposes can't be achieved by using fully anonymous data, you can should use pseudonymized data next, where you retain the link in your separate file, enabling you to tell who the people are if it's necessary for some reason to do that for the purposes of the research. Good, so that on the face of it might seem fairly helpful. One problem is that although the law in principle does allow, as I've mentioned, you to do research with health data without the subject's consent, that's what Article 9.2j we've just looked at allows, subject to those other safeguards set out in Article 89. So although the legal landscape allows that, one problem is that medical researchers and generally medical healthcare workers are subject to these additional ethical duties, such as those set out in the Declaration of Helsinki, etc., which do seem to require strong consent from the research subject. So the law here is not the only problem in terms of reusing health data. It's also partly to do with ethical requirements that have nothing to do with the GDPR, but which are just there anyway, as part of the ethical landscape in which health care workers and doctors and researchers operate. The data protection law in the form of the GDPR is also, as has been hinted at by the other speakers, not entirely helpful to researchers. It tries to be, but it does subject their activities to a lot of other sort of processing safeguards, a lot of further regulatory constraints, which are just there. They're in the instrument, in the regulation, as a sort of general instrument designed to cover all sorts of data processing, but they can be a bit of a hindrance for researchers, for sure. Some of these rights are rights of the data subject to receive quite a lot of information from the controller, those can be exempted from. Member states are, as Dr. Schneider mentioned, they can under Article 23 sometimes opt out of giving some of these rights to data subjects, but it's a bit problematic. But then, as well as that chapter of rights given to data subjects, to various kinds of information, and to some extent also occasionally to even veto the use made of their data, there is other matters. Data protection by design and default is probably not such a big problem, nor is data security. It's fair enough that the regulation wants data controllers to take all proper technical and organizational measures to protect the data against accidental or unlawful access or loss, as per Article 32. That's fine. What's perhaps more difficult are these kind of obligations such as data privacy impact assessments. I don't think that's been mentioned so far today, but it's very probable that medical researchers using health data will often have to undergo one of these assessments under Article 35. And indeed, they may also need to consult with their member states' supervisory authorities under Article 36. They're all, well, yeah, let's have a look at those two articles in particular, Article 35 and Article 36. So those do apply quite likely to controllers who engage in high-risk processing involving health data. And what Article 35 says is where a type of processing, in particular using new technologies, or taking into account the nature, scope and context of the purpose of the processing, is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall, prior to the processing, carry out an assessment of the impact. So these are sort of bureaucratic things that data controllers, including researchers who want to use health data for research, are likely to have to go and do. So it shall be required in particular, a data protection impact assessment, that is, in the case of processing on a large scale of special categories of data, including health data. And in some cases, if it seems a risk is going to remain that even with various techniques used by the controller to minimize the dangers, if there's a sense that there could still be some sort of risk left over to the interests of the data subjects, the data controller is required under Article 36 to actually approach the relevant, whichever member state they're in, they should approach their member state supervisory authority, data protection supervisory authority operating in each member state. They shall consult with that authority and talk about what they can do to mitigate some of the risks of the processing. So what that all means is that there is quite a increase in bureaucracy and red tape, ex-ante red tape, in the context of wanting to share health data for research and other public interest purposes, including the likely need for these data protection impact assessments under Article 35. And so far, the detailed ways these requirements are to be implemented by controllers are still evolving. It's complicated also by the fact that the regulation does, as mentioned, give individual member states some freedom to enact their own individual rules. Some of them have already made use of that, but not all. But it means that instead of contributing to a completely uniform regime across the EU, there is going to still be a bit of individual variance between different member states, which, especially in the context of cross-EU research projects, causes problems because it's sort of variable geometry, also different in one member state than in another, which is not the idea really of an EU regulation. It should try and smooth things out. At the same time, I think enough's been said to justify what I said earlier, that the GDPR tries to be helpful towards health data research. I think what we're experiencing at the moment is still a sort of short-term friction. After all, the regulation only entered force less than 5 years ago. And the hope is eventually some of these difficulties are going to be sorted out. Indeed, some of the mechanisms that are made available in the GDPR, such as allowing data controllers to consult in a prior way with their supervisory authorities, also codes of conduct, a very important mechanism under Article 40 of the GDPR. Those allow certain sectors of industry, including, say, medical research, to draw up their own kind of codes as to how they're going to use data in different circumstances, for different types of secondary use, etc. That could be embodied in a code of conduct, and you can go to your supervisor, your supervisory authority rather, with that code of conduct and ask for their blessing. And if you do that, that should give you quite a lot of reassurance that what you're doing with the data is okay, and you're not going to be held to account for that, as long as you've abided by the rules in your code of conduct. I think it's always crucial to be clear as to what the possible risks are to the data subject and the steps you're taking to mitigate those risks. That should always be the starting point. And in the medium term, hopefully this will all lead to greater consistency and certainty for researchers wishing to use health data for good purposes. So I'll finish there. Sorry if I took too long as well, but yeah.
Well, Mark, for very, very useful insights, and I think your conclusion, I mean, of the promise of a more easygoing future. I think it's a shared wish from all of us. We moved 18 minutes overall beyond the scheduled time, so but I think there is still another 5 minutes for question reaction discussions. Unfortunately, I have class in 12 minutes, but there's still definitely time. So please feel free to intervene with questions, comments, criticism. At least for me, I mean that would be helpful to improve. I personally would have a lot of questions to both Mark and Julia, but let's leave the floor to the other.
I see that there are some questions on the chat.
In the chat. All right. Okay. So, wow. Oh, I didn't look to the chat. So, can anonymous data ever exist? That's a nice question. If the original source personal data is still accessible, and if the software code can be rerun to reobtain the same anonymous data, if it is often trivial to remap the anonymous data subject back to the anonymous ones, should anonymous data only be called such when the original personal data does not exist anymore? That's one question. Let me read some of them. Sorry for picking and choosing from the long list. Usually the real identities are stored separately, secured and accessible only to a specific person. Yes, that's correct, but don't forget that there would be pseudonymization. There is a nice discussion going on. So I don't know if any of you, Julia or Mark, want to react to this statement / question, which is really in the data-driven society a key one. You want to react, or shall I, as you wish? Mark, Julia, Mark, go ahead.
Yeah, I think the anonymization is a very tricky topic, and I think the best assumption is always that the data is personal data. Sorry, I'm stuttering because I've got a terrible echo. I can hear myself, and it's making me self-conscious. But yeah, anonymous data, I think probably one should forget it. The only data which I think might be anonymous is where it's completely statistical data, where, I don't know, it's presented in a way that is just giving you counts of many people. But that data is probably not that useful for most research purposes anyway, at least health research. I think the better assumption is that the data is personal data, and usually the data would be in a pseudonymized form because the researcher, or indeed the doctor, wants to retain a link to the patient if need be. That may be an ethical requirement if they need to feed back certain findings to the patient that have come up during the research, which could be important for that patient's well-being. Also, if they want to perhaps gather new further data from the same patient over time in the light of the previous research. So generally, you're always going to have a connection, and you'll be using the data in a pseudonymized way. Certainly the GDPR says you should pseudonymize where it's possible, which it usually would be. But that is personal data for the purposes of the GDPR, as I said. So I think on the whole, data protection regime is not as bad as it's sometimes made out. It does try to encourage positive uses of data. It just has a lot of safeguards there and puts the onus of justification on the controller, the person using the data, to show why they really need the data and what the benefits are and what they've done to minimize the risks to the data subject. And I think that's a good kind of discipline for researchers to be able to do that, to be able to clearly justify why they need the data in the form that they need it and what they've done to safeguard the subject. And here the law doesn't know more really than sort of reinforce what their ethical obligations are anyway. So yeah, that would be my take on it. Sorry to have gone on too long again.
Thanks a lot, Mark. If I may just raise a point on that, is that the GDPR basically on the anonymity notion, especially these days with the technologies, is presenting the issue of anonymity as a dog chasing his own tail. Because if we look, for instance, to recital 25, which is basically enabling the idea, I quote literally, that the principle of data protection should therefore not apply to anonymous information, namely information which do not relate to an identified or identified natural person or to personal data, rendered anonymous in such a manner that the data subject is not or no longer identifiable, which is exactly the case described in the question. The problem is that the very same recital, a few lines above, says also that to determine whether a natural person is identifiable, account should be taken of all means reasonably likely to be used, such as blah, 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 either by the controller or by another person to identify. This means that if I fully anonymize the data I am giving to Julia or Mark, and that is basically they have no means to re-identify without my information, technically speaking, that data set in the hands of Julia, it's an anonymous data set. But if we look to the referral, potentially she could get access to my data, re-identifying. Reasonably, she has no interest. Reasonably, she has no technical tools, no economic interest, and so on and so forth. But the third party that doesn't have access to the data set or to my re-identify information might have that interest. So the third party will hack the data set in the hands of Julia, and she thinks it's anonymous, so it's less protected. and then will act my identifying piece of information. So that's where the dog chasing the tails, its own tails, kicks in. But that's something we have to try to deal from an institutional, organizational, at the same time technical way. And probably it's a topic for another awareness panel we need to organize. Julia, I don't know if you want to add something or.
No, I was just wondering whether also, also going back to the research, to the topic of research, as research could be used in order to cover maybe non-research activity, also in light of the broad research notion the GDPR provides. Also, the reference to anonymous data could be a way, to escape the GDPR's clutches, we can say. But this is just about the risks, and I think maybe moving in the realm of pseudonymization would be much more also a more legally sound choice, because it also provides proof of the compliance with the safeguards and so on.
Thanks a lot. Unfortunately, the time is the clock is a tyrant. So thanks a lot to Mark Stouch and
sorry, Giovanni. I just wanted to say something about an interesting question in the chat about kind of outsourcing data collection to the third world where the GDPR doesn't exist. I would say that the problem there is an ethical one, and you probably wouldn't get funding if you tried to circumvent the GDPR in that way. Certainly the EU Commission wouldn't fund that, and I guess a lot of people would be worried about the ethical implications. Yeah.
I think you are right. I mean, those would not be funded on the one end from the European Union, and especially if the idea is the training, the requirements and the requested so far by the proposed AI Act would take into account this part, because in that sense, the AI would be developed outside the country, outside the European Union. Now, there is an issue to be understood whether this would entail and cover also the protection from other legislation, but that's a very interesting point that Albert Salah has raised. So thanks for raising it. It's a really well taken points. Most probably it will not be happening because of other constraints, legal constraints. But that's a risk around the corner. Thanks a lot, Albert, for that.
Thanks.
All right, thank you all. So we can close this definitely interesting awareness panel. We had half an hour more than expected. That's great. Thanks a lot for all the participants, and see you to the next one in the pipeline, which is close. So watch closely the SoBigData++ and Leader Lab websites for the next event. Thanks a lot. Bye.
Bye-bye. Thank you. Bye, everybody.
Bye.
Thank you. Bye.
Bye.